was arrested by police. When he was arrested by the police, they brought him to the station and interrogated him, and he gave statements that weren't necessarily incriminatory, but they also weren't saying, he did say, I didn't do this. Oh, he said he was in Towson at the time. Okay. So that trial ends in a mistrial. And so when he is tried again, decides to testify this time. And when he testifies, he claimed then that the shooting was done in self defense, that he was there with his friend Griffin, who they were trying to buy drugs from the two deceased people. And Schuler claimed to be waiting in his car for Griffin to go get the drugs when he saw the driver of the car get in a tussle over a gun with Griffin. And that's when Schuler decided to take his gun and went up to the passenger side and, in self defense, wound up shooting both of them. So the question in the second issue in the case um, was it proper for the state to be able to play the videotaped statement that he gave police that was not played at the first trial? And it seems pretty obvious. The court says yes. I mean, if you get on the stand and you say, I wasn't there, or I just did it in self defense, and the police have a statement where you say, I was in Towson, then the state has a right to impeach him. So that one seems pretty obvious to me. So the next Fourth Amendment case is Riley. And I want to give you this site because it has a citation now. It's 266 Maryland Act 598. Okay, so this is an interesting case as well. The police are on, what did they call it? Foot stopping patrol. Never heard of that. But what it is an officer goes to an area that doesn't have a whole lot of traffic and gets out of his car or her car. And when they see a traffic violation being committed on the road that they're on, they point to the person and tell them to pull over. Okay. So that happens here with Riley. And what the officer said he saw Riley do was cross the Gore area, Gore, which I've never heard, in which is like in between lines in the and they use it as a traffic control device. Anyhow, there is a statute that talks about this Gore area and how you can't, you're not supposed to cross it. So that formed the basis for pulling or telling him to pull over. Now, once he was pulled over, the officer goes up to Riley's window and he asked for his license and registration and told him why he had pulled him over. The officer said that he smelled a strong odor of marijuana coming out of the vehicle. And so he got on his phone and told his shift partner that he would be conducting a probable cause search of Riley's car based on the smell of marijuana. So they he wound up searching it and he found I believe it was a backpack that was filled with marijuana and had a live gun in the backpack. So he arrested the defendant for this, and the defendant said it was his gun. So there are several issues in the case. The first issue is, did the court err in allowing this officer or finding that he had probable cause to stop Riley based on this Gore that he went over? And the reason the argument goes is that it didn't hurt anybody and nobody was in danger of this traffic violation. But of course, we all know any traffic violation is sufficient to pull you over. So the court puts that aside and easily dismisses that argument. The next argument that Riley makes is that the traffic stop was unlawfully pretextual, but the argument is made under the Maryland Constitution, not the Fourth Amendment. So the Supreme Court of Maryland held in this case that, or the Appellate Court of Maryland held that Maryland has always interpreted its, I think it's Article 26, yeah, Article 26 in its Constitution to be in pari materia with the Fourth Amendment and the way that the U.S. Supreme Court has addressed any particular issue. The court also pointed out, interestingly, I think, that even if the Maryland Declaration, Article 26, could be looked at differently from the Fourth Amendment case law, that Maryland Declaration Article 26 does not refer to an exclusionary rule. And they point out that Maryland has never adopted on its own an exclusionary rule. So if you ever want to use the Declaration of Rights, Article 26, you're going to have to come up with a good argument for why there should be, or it should be, an adopted exclusionary rule. Okay. Third issue in this case is, did the police have probable cause to search Riley's car? And based on the odor of marijuana, the argument is that the new law that was passed not too long, it went into effect in July 1 of 2023, which says that you can't rely on the smell of marijuana and call that probable cause. So what's interesting about Mr. Riley's case is, at the time his car was searched, the law was not in effect yet, okay? At the time of his motion to suppress hearing, however, the law had gone into effect. And so Riley was arguing the important date is the date of his motion to suppress. And the court said, no, the date is when it went into effect. It's prospective only and not retroactive. So it could, because at the time this law was not in effect when the officer smelled the marijuana and searched the car. Based on that, it was not an unlawful search. And the last argument that Riley makes is, when the officer got the gun out of the backpack, he said, "Whose is this?" And the defendant said, "It's mine, it's mine. Don't worry, it's mine." And so the question that he raised on appeal is that the lower court should have granted a motion to suppress his statement that the gun belonged to him. And the appellate court agreed. And the reason is, the court said that normally a brief investigatory stop for a traffic violation, and if questions are asked at that point, answers are given, that's not a problem. But here it was prolonged, if you will, because he asked several questions. And he also, I forgot to tell you, had Riley handcuffed at the time. So he was clearly in custody, no question about it. And he was clearly being asked questions by the officer, whose gun is this? And so the court said that because he was in custody and because he was being interrogated, he had to have been read his Miranda warnings. And he wasn't, so they suppressed the statement that the gun is mine, okay? Next, on to Harley. The Harley case deals with police responding to a call of an armed robbery in a residential parking lot. And when they get to the scene, they find a woman standing there by herself, and she ran to the police and said that she had been robbed by two men wearing dark clothing at gunpoint, and she described the gun as being black and silver, and that they had pistol whipped her with the gun and had stolen her purse from her. And so, and she said that inside the purse she had some money, she had her car keys, her house keys, and her identification, and as well as her bank cards. So while the police are there at the scene talking to the victim, she gets a notification on her cell phone that her bank card has just been used at a gas station that was only like less than a third of a mile away. So the police get in their car, they go to to the gas station, and the car, whoever it was gone. There was nobody else there as a customer. And so what the police did is they got the video, the gas station video, and they looked at it, and the victim identified the two people in the video at the gas station as those that had, in fact, robbed her. So the police also get it's a Sonata is the type of car, and they got the license plate from it, from the video as well. So later that night, the police find the Sonata, the same car, parked in a residential area, running. It was still running, and it was unattended. No one was in there. And then, so the police kept it under surveillance for a bit of time. And shortly after that, they saw two men in dark clothing come out of a home that the car was parked in front of and begin to get into the car. The police stop them, arrest them for the robbery. And inside the Sonata, they find, I think it was her driver's license. But they did not find her purse. They did not find the gun that she said they used, and the other identifications that she had, bank cards, were not in that car. So what the police decide to do after they've taken the two men away, including Harley, and place them under arrest, they get a search warrant, okay, for the home that they saw the two defendants walk out of, okay? And the home, I should add, was only a few blocks away from the gas station that they had just been at. So they get a search warrant to search the house, but while they're out trying to get it, two other officers went up to the door, knocked on the door, and explained why they were there, because of this car they saw these two men go to coming out of the house. And Mr. Harley says, well, all right, you can come in, and he's answering questions for them. So about, I think it was close to like 3 hours, the police were there total in Mr. Harley's house. He started yelling at them to get out of the house. He didn't want them there anymore. And they said, no, we're staying here until we get the search warrant. So they finally do get the search warrant after, like I said, 3 hours or so. And using that search warrant, they go in the upstairs, they're searching, and in a bag that was in the hallway, they find like 11 pounds of marijuana, and they find a ghost gun. So, of course, neither of these, the marijuana or the ghost gun, had anything to do with the woman victim who had been pistol whipped earlier. So the police, what they decide to do now is they stop searching and they stay in Harley's home again for more time and send another officer to go get another warrant based on finding the ghost gun and the marijuana. And so they came back, they got that warrant, came back, searched all over Mr. Harley's house. They found a lot of ghost guns, they found marijuana, and they found a 3D printer. So now that Mr. Harley is under arrest. The argument that Harley makes is that the motion to suppress should have been granted for several reasons. One is that the police had no idea why those two guys were in Harley's house, and they had done nothing to, make it appear that they were ditching what they bought or what they stole at Harley's house. And so the Court on Appeal said, nope, what we have here is the independent source doctrine that must apply. Now, the independent source doctrine applies if law enforcement engages in some illegal conduct. And here it was refusing to get out of Harley's house when he told them to get out. Okay. So that was illegal conduct by the police. But if the evidence that they wind up finding is discovered by a lawful means, i.e., the second search warrant here, then the independent source doctrine applies, and the evidence is you don't have to suppress it. So again, the fact that the police stayed there against the Harley's wishes wasn't really what led them to the evidence that they seized. It was the search warrant that a judge had granted based on probable cause. Okay. So the independent source doctrine, they fleshed that out in the Harley case. The Booker case is next. And I really hate this case, but cop is patrolling on foot and he sees Booker sitting on some steps near a convenience store. And then somebody comes out of the convenience store and gives Booker what appears to be food. And the officer testified that when the guy approached Booker and greeted him with a handshake, Booker tried to stand up, and the officer noted that he kept his right hand, left hand, whichever one it was, up against his body, the pocket of his jacket that he was wearing. And excuse me? Oh, and so the officer thought that was odd, and he could tell that there was a heavy object in the pocket. Okay, and the guy Booker had his cell phone in his hand. So the officer deducted that it wasn't a cell phone in his pocket, but it is something obviously heavy. And he testified that when people carry a handgun in either their pocket or their waistband, they have this movement when they're standing and walking that's called blading, B-L-A-D-I-N-G, which is sort of walking sideways and holding your hand over your pocket. And the officer testified that in his experience, that this blading is a way to try and hide a handgun. So the officer approaches Booker and says what he saw and asks Booker if he had a weapon on him. Booker denies this. And so the officer winds up frisking Booker. And sure enough, when he feels what feels like a gun, he reaches in the pocket and gets a gun. So the issue is, was this enough reasonable suspicion to conduct a stop and frisk? Because all of the movements he made, including the blading, were relatively innocent, were innocent movements. And so the court made it very clear, because they found that there was sufficient reasonable suspicion to stop and frisk. But the court made it very clear that it was not saying that a stop can be solely based on a waistband adjustment in a high crime area. Okay. And they try to walk it back, but the big point they thought was important was the blading, which is only a police officer would recognize because of his experience. And so adding that to the fact that there was waistband adjustment and it was a high crime neighborhood, that all added up to reasonable suspicion to stop and to ultimately frisk Mr. Booker. Those are all the Fourth Amendment cases that have come out this year, which is actually a lot, because I don't know the last time we've had 5 or so Fourth Amendment cases in 1 year. The next one, though, I want to talk about concerns the Fifth Amendment. And this is a case where Mr. Campbell was, police get a call that a man has been shot in his eye at this parking lot by a hookah store in Baltimore County. And so the police go, and each of the police officers that got there testified that it was just crazy. There were so many people in the parking lot. screaming and wanting to talk to the officer. The gentleman that was shot ultimately died. Okay. So what the police do while they're trying to settle everybody down, they wind up they sent one of the officers to get a video camera from inside the lounge and then got the video camera from outside the lounge in the parking lot. And when they looked at both of them, they could see who turns out to be the defendant in this case inside the lounge and outside the lounge. And the person who is outside the lounge clearly is the one that shot and killed the deceased. So when they bring the defendant in for questioning, just to try and investigate, so it was not they were interrogating him. They showed him first the video from inside the lounge, and he identifies himself. He said, "Oh yeah, that's me." And of course, I don't think he realized that they also had the lounge. I mean, the video from outside in the parking lot, clearly showing the defendant in the same clothes shooting and killing the gentleman. So the question on appeal is whether or not the statements that he made during the custodial interrogation should have been suppressed. And the argument is for this reason, because you really can't get around that there was probable cause. And so the argument was that when the officer told Campbell what his Miranda rights were, and he said he would waive them. And so they had the waiver form and they put it in front of him and he initialed each one, and showing that he would waive his rights. And at one point then he stops and he says, like I'm waiving all these rights, right? And the officer says, yes, but if at some point you want to stop. And then Campbell interrupts him and says, I still have these rights, right? And the officer, this is what Campbell claimed on appeal, was a misstatement of the law. The detective said, oh, yeah, you have them, but you're still you understand them and you're still going to talk to me. So the argument is that that was a misstatement of the law because he had already waived his Miranda rights. And by saying, you still have them, the argument was that's not accurate. But of course, it is accurate. And so the appellate court said, look, once you waive your Miranda rights, doesn't mean you can't re-invoke them or invoke them later. So it didn't matter that the officer said what he said because it was clear that he could invoke his rights at any time. Okay. So that's the Campbell Fifth Amendment case. Let's see. Oh, the other argument in the Campbell case is that when the police were questioning him at the police station, he was wearing yellow prison garb, and it had BCPD on the back. And so, but you could not see the back, and the state redacted the video that they had, not allowing it to show him walking out the door so you could see those letters on his back, but he's still wearing yellow prison garb. So his argument was that the videotape from that interview should have been suppressed because he had prison garb on. And the court said, the court held that normally you're not allowed to see, you shouldn't see somebody in prison garb. The jury cannot see a defendant in prison garb. However, the court said that given what the state had done to redact and not allow to see the lettering on the back, that this was sufficient and that it was the video of the actual statement was more probative then the garb was prejudicial. So the court said it can come in that it was relevant to the voluntariness of his statements to the police. Now, Jared, how long should I go? Because I want to pick just the best cases that I think are interesting.
Sure. Up to you, maybe 15 more minutes.
Okay. All right, good. So then let me go to, there's a case that, okay, this would be on page 15 of the handout, and this is the Johnson case. And the holding, I'm just going to give you the holding and not so much all the facts, but the holding in Johnson is that battery or a severe battery against a member of one's family or a close friend can amount to adequate provocation. There had never been any case in Maryland that applied it to a close friend or a relative. It had always been the defendant himself. So a substantial battery against a close friend or relative does amount, or can, I should say, amount to adequate provocation that could reduce murder to manslaughter. And that's exactly what happened for Mr. Johnson. The next case that I think is important for you to know is on page 17, Van Gorder, which is a holding, the bottom line holding in that case is one's sexual orientation is never relevant in a case. And this is a case of child abuse, sexual child abuse. And the state argued that because the defendant was bisexual, that helped them to establish his intent was for a sexual purpose and gratification when he touched the child. The court said absolutely not. Never relevant, okay? The Akers case is sort of like that, is a bottom line holding. And the bottom line holding there is that it is not relevant ever to introduce evidence that and Akers is a woman was searching her computer for information on stillbirth and on abortion, nor is it ever relevant that she did not seek prenatal care, because the state had introduced all of that, all of these, things that she'd gone on her computer Googling to suggest that just showed that was her intent when the baby was going to be born, to kill the child, okay? That's never relevant. And it's really a well-written opinion too, I might add, that talking about women's rights, if you will. Okay, another one I think is intriguing is page 19, and it's Crow-Marty. And the bottom line on that is, that you have the right to sequester witnesses outside the courtroom. But there's an exception to that rule that allows the state to choose a representative that can stay in the courtroom, even if the person is going to testify. And the Supreme Court of Maryland held that that's true, that the rule does permit that. And so that the fact that the prosecutor said she wanted the lead detective to be her representative and sit at the counsel table with her was not a problem, okay? But the Supreme Court of Maryland said that they were referring this rule to the Rules Committee to fix that. So while it could not help Crow-Marty, it may help folks in the future that they can't pick a witness to be their representative. Let's see. If you want an interesting read the Crawford case at page 20, where a former police officer set a lot of fires on arson on garages that some burned down houses, and he did it more than once to a single person. And it turns out that he had done this in other counties, 8 in particular, and that he had a list on his phone of the names of each of the people's homes that he had burned or, set on fire. But it's a really interesting opinion. Let me see. All right. The June case, JUN, on page 21, is a appellate court of Maryland case where they claim that it is within the ken of an ordinary person to know what IP addresses are, to know what a kick app is, to know what kick records are. I'd never heard of it myself, but the argument was that this requires the testimony of an expert. And like I said, the appellate court said, oh, no. Everybody knows what these things are. So it doesn't need to be an expert. But interestingly enough, the Supreme Court has taken certain that, and I think they're going to wind up reversing it. I'm not going to go through the juvenile matters because they're pretty straightforward as well. Let's see. Okay. The Williams case on page 26 deals with the gang statute. One of the statutes says that it was a felony to organize, supervise, or promote a criminal organization. And it defines criminal organization to include gangs. And what happened here is Williams, who was a young man, stood guard outside a building that his 2 gang buddies were spray painting with their gang logo. And so he was convicted of promoting the gang or the criminal organization. And the Supreme Court of Maryland said, no, that's not promoting. That the only way that you can promote it has to be the person has to exercise a leadership role of some kind in that gang. So that didn't apply. Now, the other important case I'll say real fast is the Palmer case, which is on page 27. This is a case that I was stunned at, to be honest with you. So the defendant is stopped, or the police come up to the defendant who is not in a car, but the car that he's around has taken down, I think it was a speed limit pole, and it crashed into, I believe, a tree. So that's when the officer gets there, and it's like 11:30 at night. And so he starts talking to Palmer, and he asks him if he had been drinking, and Palmer said yes. And the trooper never asked him anything more about the drinking and driving. The question is, in the case, is the evidence sufficient to prove driving under the influence of alcohol and driving while impaired by alcohol when the evidence never shows when the person was driving, meaning literally when they were driving, and when they were drinking? And the court makes a lot of good statements if you're representing the defense. It says the mere fact that Palmer was found under the influence of alcohol at the scene of a single vehicle accident does not support a finding that he was under the influence of alcohol at the time he drove the vehicle. Okay? So there has to be a connection. The state has to make a connection. Let me see. I think, have I used up my 15 minutes or?
You're almost there. You can do, I mean, obviously we're here at your disposal, maybe 1 or 2 more.
No. I just want to go through because there are some that I think really are important. And the other one that I think is important for your purposes is, okay. The Towns case, which is on page 33. Bottom line on that case is, and it's really emphatically said by the court on appeal, judges should not engage in trying to get involved in plea negotiations because that's what the judge in this case did. And the court, while they affirmed the issue that was raised, they said courts should refrain from being involved in plea negotiations. And it's very firmly stated, actually. So if you ever have that happen, that's reversible error. um, that's easy to understand. I do want to show you, unfortunately, there are two U.S. Supreme Court cases that this Supreme Court granted cert on that really worry me. And this is on page 43. And one is called Villarreal, where the question presented is whether a trial court abridges the defendant's Sixth Amendment right to counsel by prohibiting the defendant and his counsel from discussing the defendant's testimony during an overnight recess. Now, Maryland, I will tell you, in a post-conviction matter, which I can't remember the name of, but there is a Maryland case out there that's relatively new that says that if that is ineffective assistance of counsel, if counsel doesn't object to being told during a recess, you can't talk to your lawyer. And I got a feeling that the U.S. Supreme Court is going to come out differently on that. And then the other case in the Supreme Court U.S. is Case versus Montana, which really worries me. The question there is whether law enforcement may enter a home without a search warrant based on less than probable cause that an emergency is occurring, or whether the emergency aid exception, which we know exists, requires probable cause. That one worries me very much because I think they're going to say, no, it's just reasonable suspicion because you need to get inside to help someone. And that will be reversing the law as it exists now. And I also gave you a expungement law handout to show you what the old law was and how it's changed up to the new law that was passed in 2025. So you can compare them and see what the new law allows for now. All right, I think I touched on the cases that I really wanted to make sure you all I could bring to your attention.
That was fantastic, Nancy. Thank you. And also, this is the type of programming you can expect from the Criminal Law Committee, short and to the point, with a handout that you can save on your computer so that a week or a month or a year from now, when one of these issues comes up and you go, I think I remember hearing a case about it, you can find it again. So, Nancy, a debt of gratitude. This is now your second year in a row, and I'm sure we will ask you to do it again next year. I don't know if you can see the chat, Nancy, but from far and wide, people are singing your praises in the chat. Super helpful, super amazing. Thank you. If you didn't get the handout, email me or Rachel, and we'll send it to you, but everybody should have it. I think Carly had to painstakingly copy and paste each email address from registrations, so that's why it took some delay in getting out. I want to thank you, Nancy, for your time and your wisdom and your experience, and thank you everybody for coming out to this event.
Yes.
And with that, I will conclude and wish everyone a happy Thanksgiving.
Thank you.
Great.
Bye, Jared.
Thanks, Nancy.
All right.
Jennifer.
Thanks.